We are at week 9, talking about the Constitution a little bit in depth. And today we're going to cover the legal amendments. So we have a bunch of legal rights as Americans, and our founding fathers wanted to make sure they were very clear. So they captured them in the Bill of Rights, in the Constitution. So today we're going to plow through Amendments 4 through 8. This will be a little bit longer than some of the other talks, but it's important, and then we can move on to some of the other really more exciting rights. Although these are so foundational for us. Okay, all right. So today we are talking about a whole bunch of our legal rights. Okay, so let's start with Amendment 4. Amendment 4 says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons and things to be searched. All right, so this is really important. This Fourth Amendment, if you think about authoritarian fascist regimes that have started, they have not had these rights. People's homes and their persons could be invaded and searched for no reason at all, except for maybe the local officials or the government was upset with them. So it is important that our founding fathers enshrined Amendment 4 in our Constitution. Now, we know that our Constitution, even though it has these powerful rights, is not always applied in a just way. I know for my Black friends who have teenagers, they have to have the talk with their teens when their teens start driving about what happens if they are stopped at a traffic stop by a police officer. So there's still things in our American society where our Constitution is not fully active. And what do we do with those things? We, the people, talk to our elected officials. So let's dig into Amendment 4 real quick, okay? All right. So first part of Amendment 4, all right, is it says that the right of people to be secure in their persons, houses, effects, papers against unreasonable searches and seizures shall not be violated. All right. So searches and seizures inside a home without a warrant are presumptively unreasonable. So the courts interpret this, though. They're the ones who, when cases come to them, they decide what is unreasonable search and seizure. So here's some court decisions, when the feet on the ground of how the courts have interpreted the search and seizure clause. So in homes, an officer has been given a consent to search if that's a warrantless search can happen. So if an officer knocks on the door and says, "Hey, I want to search your house," and you go, "Okay," then that they don't need a warrant. It is okay if the search is incident to a lawful arrest. So if they're already arresting a person, they can do some searching. If there's probable cause to search and exigent circumstances, or if there are illegal things in plain view. So that is when a warrantless search can be lawful according to the courts. Unwarrantless search of a person can happen when an officer observes unusual conduct, which leads him reasonably to conclude that criminal activity may be afoot. The officer may briefly stop the suspicious person and make reasonable inquiries aimed at confirming or dispelling the officer's suspicions. One of the cases they talked about at the National Constitution Center's website is a guy who was walking back and forth in front of a small business, and he did about 20 times. So the foot patrol cop goes like, "What's up with this?" And so he just stopped and chatted with the guy, and he evidently had a weapon and with intent to kind of visit the store with bad intentions. So, um, all right, schools. School officials do not need to obtain a warrant before searching a student who's under their authority. Rather, a search of a student need only be reasonable under the circumstances. Cars, warrantless searches about cars. This is interesting. There's a bunch of ways officers don't need warrants. If there's probable cause to believe a vehicle contains evidence of criminal activity, an officer may lawfully search any area of the vehicle in which evidence might be found. Or an officer may conduct a traffic stop if he has reasonable suspicion that a traffic violation has occurred or that criminal activity is afoot. Or an officer may conduct a pat down of a driver and passengers during a lawful traffic stop. The officer need not believe that any occupant of the vehicle is involved in criminal activity. Or the use of narcotics detection dog to walk around the exterior of the car, subject to a valid traffic stop, does not require reasonable explainable suspicion. Or special law enforcement concerns will sometimes justify highway stops without individualized suspicions. Or an officer at an international border may conduct routine stops and searches. Or a state may use highway sobriety checkpoints for the purpose of combating drunk driving. Or a state may set up highway checkpoints where the stops are brief and seek voluntary cooperation in the investigation of a recent crime that occurred on the highway. Or a state may not use highway checkpoint programs whose primary purpose is the discovery or interdiction of illegal narcotics. So those are some of the ways the courts have interpreted the probable cause. Okay. All right. So what keeps our government from overstepping? Because some of those things, in my opinion, sound a little bit of overstepping of a Fourth Amendment. We the people. You use your voice. So I remember back in the day, personal story, when homeschooling was a new thing. And so we were, in the front lines as homeschooling parents of starting a new cultural thing. And the courts and all did not know what to do with all these homeschoolers. So often the school districts would send truant officers to the door who wanted to come in and search the house and make sure everything was okay. Just kind of not very Fourth Amendment friendly. But what the homeschoolers did is they banded together and got legal representation and training on how to handle truant officers at the door. So Homeschool Legal Defense Association was born during that time. And so we had truant officers at the door drills. And if a truant officer came to the door, we just handed the phone out to them and they talked to HSLDA. And that usually just made things disappear, usually. But at the same time, we, the people, were contacting our elected officials and saying, Fourth Amendment, let's pay attention to that. And so these days, you rarely ever hear truant officers at the doors. All right, let us go on now to Amendment 5. So you have all heard the Fifth Amendment, right? So all of us have grown up watching, crime dramas and things like that, where there is a Fifth Amendment discussion. So I plead the Fifth. So this is what it says. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentation or indictment of a grand jury, except in cases arising in land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. They crammed a lot into Amendment 5. So let's talk about that briefly. All right, so many of the rights in the Fifth Amendment are rooted in Old English common law. The grand jury clause has roots all the way back to Magna Carta. So these are things that were familiar to our founding fathers, and they wanted to capture it in words in our Constitution so it couldn't be ignored or taken away. Because as we know, their experience with the English royalty, that sometimes they would ignore, overlook in the colonies what the common law or the Magna Carta might have said. So they want to make sure Americans had these rights enshrined in our Constitution. All right, so let's talk about the grand jury clause. So no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So the grand jury clause says that grand juries are required of a capital crime or other infamous crime. A capital crime is a crime punishable by death. An infamous crime is usually a felony crime involving corruption or fraud and has significant public notoriety. So you probably heard, grand jury this or grand jury that. And so those are Fifth Amendment kind of trials. So there was some capital or infamous crime being looked at by the grand juries. Next is the double jeopardy clause. All right, so that no person can be subject for the same offense to be twice put in jeopardy of life or limb. So the double jeopardy clause says a person can't be tried twice for the same crime. All right, so this doesn't include mistrials. Every once in a while you'll hear about a mistrial and they just start all over because something went wrong. All right, self-incrimination. So no person shall be compelled in any criminal case to be a witness against himself. All right, so you hear people sometimes on television, or when we have televised congressional searches or discussions, you hear people say, I plead the fifth, I plead the fifth. And that means their Fifth Amendment, they're not going to testify against themselves. This is also, interestingly, the root of the Miranda rights that officers are supposed to read to people being questioned. And that's based on a 1966 Supreme Court decision. So part of the Miranda rights says that you're not required to testify against yourself. You have the right to remain silent. All right, then there's the due process clause in there. So, nor be deprived of life, liberty, or property without due process of the law. The due process clause is going to take a minute, and you can just read and watch videos on this forever. The legal people get all excited about that. But due process is enshrined in the Fifth Amendment, and it is also further protected or incorporated at state level. So it's both federal and state level when they added the 14th Amendment. All right, there are three kinds of due process. One is procedural due process. Another is the due process incorporated against the states. That was the 14th Amendment. And three is substantive due process. So really quick, we're just going to look at procedural due process. Procedural due process means that the legal system has to follow a process so that you're not depriving people of life, liberty, or property improperly. This usually means a jury trial is required in federal cases, but there can also be due process as long as people are receiving some kind of notice, have the opportunity to be heard, and have some kind of impartial tribunal. There's just, if you ever are on the wrong side of the law and something, and you feel like this isn't going right, somebody's ignoring some of my rights, there may be a due process issue, in which case, that's why we have good legal representation. Find some. All right. The other one we want to talk about quick is substantive due process, and that is simply the due process that covers rights not enumerated in the Constitution. So, substantive due process recognizes that we have our natural rights, and they are so many that they cannot all be captured in the Constitution. And therefore, the Supreme Court has reserved for the courts the right to interpret our rights, to look out for those rights, even when they are not specifically listed. So that legal system has to pay attention to our substantive rights, our natural rights, even when it's not specifically set in the Constitution. Okay. All right, the last one in there is a big one if you've ever experienced it, and it is called the takings clause or the eminent domain clause. And it says, nor shall private property be taken for public use without just compensation. So sometimes the government needs a person's property. And they need to build a road or they need to build a government office or something. And so they're allowed legally to take your property for public use. However, they must give the person just compensation. So that, in tradition in England, the just compensation part was not always there. So our founding fathers wanted to make sure that if the takings, the eminent domain, needed to happen, people were not treated unfairly. All righty, let us look at Amendment 6. Here we go. All right, Amendment 6 says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime may have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have a compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his defense. So a lot of stuff going on in that one, right? All right. So the first part of Amendment 6, people have the right to a speedy and public trial. So trials need to be conducted in open and transparent situations and with reasonable speed. Sometimes we hear about people sitting in jail for months, before they have a trial. But what the founding fathers were after is people not roasting in the jails forever, and never being tried or, facing an opportunity for their freedom. So they say a reasonable speed needs to happen with the trial. All right, people have a right to an impartial jury. The accused has a right to be tried by an impartial jury, and that's what you have jury selection. Most of us have, at some point or the other, sat in the jury selection process, whether we've been on a jury or not, and that's because the lawyers are looking for an impartial jury. They are to be tried in the state or district where the crime is committed, unless there are circumstances that make that unwise. And so every once in a while, you'll hear a relocation of a trial. Part of our Miranda rights are in the right to be informed of the nature and cause of the accusation, that it is not a secret. You can't arrest people without that just cause. People need to know why they are being arrested also, and what they're being tried on. All right, so the right to be confronted with witnesses against him. So what that means is the accused person has the right to confront the witnesses that are testifying against him. So that's why we have lawyers that do the cross-examination in a jury kind of situation. The people have a right to obtain favorable witnesses. That means they get to make sure that there's somebody there who can witness on the stand on their behalf. And they have the right to assistance of counsel for their defense. And so these are important things. These people our founding fathers enshrined these things because they ran into issues with it, before the Revolutionary War. All right, so the Sixth Amendment guarantees the right to legal counsel for the accused. Interesting, it took until 1893 with the advocacy of Clara Shortridge Foltz, who was California's first female lawyer, to make sure that there was a role of a public defender, a person who worked for the state, who helped make sure if people didn't have a lawyer, there was somebody to defend the public. So there was, enshrined in the system, a way for people to have legal defense. Interesting, it wasn't until 1963 that the courts decided that they had to make sure there were lawyers, even if people could not pay for the lawyers, so that the public defenders were on the state's role. So when people could not afford to pay a lawyer, they had some help. All right, so that is our Sixth Amendment. Let's look at our Seventh Amendment. Amendment 7 says, in suits at common law, where the value of controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by jury shall otherwise be reexamined in any court of the United States than according to the rules of common law. So that is a big amendment for people who have civil cases. So the common law in this case is referring to civil cases. All right, so they have, they always have names for these clauses. So in suits at common law, where the value of the controversy shall exceed $20, the right of trial by jury is preserved. This is called the preservation clause because they always have to have names for them. All right, this law preserves the right to a civil trial in federal cases where the controversy is greater than $20. Of course, $20 back in the times of the founding fathers was a lot more than it is now. But we are one of the few countries in the world that allows civil cases, not criminal cases, but civil cases, to be tried with a jury. So if it's an important enough civil case, you will occasionally hear of a trial with a jury happening. All right, the other part is that no fact tried by a jury shall be otherwise re-examined in the court of the United States than according to the rules of the common law. That is called the re-examination clause. This clause prevents judges from overturning a jury's decision according to the rules of the common law. So the common law part is takes a lot of legal expertise, so we're not even going to touch that. But what it means, if a jury makes a decision and the judge doesn't like it, he has to listen to what the jury said. That's the way that is. All right, so that was a quick one. And then the last one is the Eighth Amendment. Eighth Amendment says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. And so you have probably heard the term cruel and unusual punishments, at debate for something or the other over the years. So the founding fathers took this particular amendment from the roots of English Bill of Rights. Did you know there's an English Bill of Rights in 1689, and also Virginia's Declaration of Rights from back in the early statehood period. And what they were interested in was protecting people from being stuck in jail because of excessive bail or being slapped with excessive fines, and then definitely this cruel and unusual punishments clause. All right, this was really, really important. They talked about this in the Constitutional Congress so many times. So, like Patrick Henry was afraid that Congress itself might get to be too powerful and they might start implementing Inquisition type tortures against their opponents. And so they wanted to make sure that no Inquisition happened in the United States. So this cruel and unusual punishment clause was inserted in Amendment 8 along with our checks and balances, as we know, are all through our Constitution, so that no part of the government is too strong. Other members of that constitutional Congress were worried that the president or the executive branch would overreach and would, like in the old days in England, people could just be locked up in the tower forever or drawn and quartered or things like that if they made the king mad. So they didn't want the executive branch to have the right to cruel and unusual punishment. So they made sure, along with our checks and balances, we have a protection from things that are evil. So that is where that came from. All righty. So we in America have our rights. We may not agree always with the way the courts interpret rights, like they still haven't finished deciding if the death penalty is a cruel and unusual punishment. And anytime that we, the people, don't agree with how the courts interpret our Constitution, or if one of the branches of government are trying to ignore part of the Constitution, we, the people, have our First Amendment right to petition, to use our free speech, and to peaceably assemble. So don't forget them. They matter. Your rights matter.